This is the American Law Journal.
9 to 5, throw it out. A central office, it no longer exists. Welcome to the virtual workplace, and anything you say on social media can and will be used against you. Good evening, I'm Christopher Naughton. This is the American Law Journal, and tonight the intersection of social media and the workplace. Three great guests join me. Let's go ahead and meet them. Anthony Haller is recognized as a leader in labor and employment law. Chambers USA says that he's an excellent attorney who would be near the top of anyone's list for employment litigation, and I've heard many an employee attorney say that they are dazzled by his brilliance and his British accent, which are both completely disarming. He is the chair of the labor practice group at Blank Rome. Michael Trachtman is with us once again, general counsel for MEA. That's the Mid-Atlantic Employers Association. He's a prolific author, an adjunct professor at Villanova University School of Law. And in his spare time, he's also a president and shareholder of Powell Trachtman in King of Prussia, Pennsylvania. And George Kounoupis is back in the ring, a pugnacious employee's attorney in discrimination, retaliation, and wrongful termination matters at the workplace. Listen up if you're an employee. George is going to school you tonight on the do's and don'ts of social media on the job. So let me go ahead and pick up from what I said just moments ago. The workplace is no longer relegated to a specific time and place. We have the virtual workplace. We have the virtual water cooler. At the end of the day, what's driving this is social media.
What's driving it is technology. Technology is always ahead of the law, and the law struggles to catch up. And that's what we have here. If you look at the broader picture, that's what we have to start with. If we're to arrive at a unified theory of social media law, we have to start with the concept that technology is always ahead of the law. And the law struggles to catch up. You can see it in cloning, and you can see it with extension of life issues, and you can see it in the cave when the first caveman brought in fire and he said, "This mine," and the rest of the cave said, "You know, you could burn us with that." So you know technology is always ahead of the law. But as the law struggles to catch up with technology, we have social issues, privacy issues, speech issues. So that's it. The lines have now been blurred. The workplace is a virtual water cooler. There is no distinction now between the four walls of the workplace and this workplace that has gone beyond the borders. But as those lines blur, we get into difficult areas.
Well, I mean, I think this is what employers are struggling with, which is where is the line to be drawn between something that is purely private conduct, perhaps off-work conduct that normally you'd think has nothing to do with the employer, and when does the employer have an obligation to do something? There is a really fascinating case I just read out of California, Espinoza versus the City of Orange, where an individual with a disability, he had a deformed hand. It's just basically a stub on his hand, and people around him at work was making fun of him, and they created a blog site and started saying all kinds of very rude and obnoxious and offensive things on the blog site, started calling him the rat claw and things of that nature, wow. Things at work, and there was just a jury verdict against the employer for nearly $1 million because the jury did not feel the employer did enough to deal with the activities of co-employees at the work site. Even though it was a blog site, it was not sanctioned by the employer. They told people to not do it. They issued memoranda.
So they didn't know about it, and they
knew about it. They tried
corrective
to do
action.
But the jury did not think they did enough. They didn't fully investigate. They didn't discipline people. They knew that although they prevented people from going on through work computers and using work passwords, people were able to do it through their own personal passwords and email systems at work, and the jury just didn't feel they did enough. And so as a result of something you might think was not sanctioned, was not anything the employer wanted to happen, there's $1 million verdict against them.
No doubt that case is on appeal, I would have to think.
It's absolutely on appeal.
Right, of course.
And there are many
right.
issues, as
right.
George said, because there's a collision of different concepts here: free speech, privacy and off duty conduct. What are the obligations of employers to do things when they're put on notice? Here's the problem, Christopher, because the conundrum arises because people on social media sites like Facebook, MySpace, and others are friends with people at work. That is, they allow them onto those sites. As soon as that happens, things that are said are no longer purely private because they get back to the employer in many ways. We've had a number of cases where there have been direct threats of violence posted on a Facebook page. Employer cannot ignore that, because if you do, there's liability. If somebody is saying very offensive things about a female employee, who's either one of the people that has access to that site or a friend has access to that site, and then she goes and tells the employer, says it's offensive and I don't like working here because these people are saying this about me, the employer has to treat that as if it's just a normal complaint of sexual harassment in the workplace.
Mike Trachtman, then what this turns into is a full-time job or jobs where companies will have to hire probably young people, maybe young lawyers, to consistently be scouting every type of social media for virtually every employee?
Well, that's a real problem. There's a downside to that as well. There's a risk for the employer, and that's the other side of this coin. Not only might an employer be liable, as Anthony and George talked about, for not stopping social media posts by an employee, but the problem then becomes that an employer may become liable if it also tries to stop the posts by the employee, and if it monitors the posts by the employee. The employers are in a real conundrum here, and it's the reason it was pointed out by George.
Yeah, but you know that, Mike, that most of the cases where there's a problem is where, companies are busting using passwords and breaking into places. I mean, look, for the most part, if these are public sites, if Facebook is a public site, so if you're putting your entire life out there, which other generations besides ours seem to like to do, then anyone has access to that. I'm talking more about maybe the burden on the employer, because now they have to put time and resources into examining all of this, because as Anthony was saying, if you miss one, you can get dinged pretty good for $1 million or better, as opposed to, and we're going to get to this, an employer getting into places where maybe they have no right to be.
But there's the other side to the coin is that I'm not aware of cases which impose an affirmative obligation on an employer to ferret it out, as opposed to do something when it comes to the employer's attention, or it should have come to the employer's attention. But the problem is oftentimes when employers do monitor the sites, they find out things that they're not supposed to know. And that's the other problem that you have when employers monitor sites. For example, employers aren't supposed to ask certain questions on applications such as religion or disability or age or such things as that, whereas many of those things become obvious when you start looking at people's social media sites. And now you have questions when an employee is terminated, for example, as the result of supposedly a disciplinary problem, and the employee proves that the employer was monitoring the employee's site and found out that the employee has a disability or is a member of an offbeat religion that some people would consider a cult or whatever. Did that influence the employer's termination or disciplinary decision? And you're getting it from both sides.
Well, it comes down to this simple phrase, if you will. It's a headache for the employer, and let the employee beware.
Well, and it doesn't end there in terms of using the information you have in a discriminatory fashion. It's also how you use it to discipline. For example, there's a recent case where an individual had accessed pornographic material. He was an African American. And of course, the idea was that they targeted him, but not other people that were outside the protected category. And in that particular case, the supervisor was asked, the HR person, why don't you do a random sampling to see how many non-African Americans did this? And he refused. And the court based its decision that there was there's race discrimination, Title VII violation here, because the internet policy was used in a discriminatory fashion. Lots of traps all over the place. But it's damned if you do and damned if you don't, because like Tony said, there's so many risks, there's so many ways a company can get burned. With the FTC, with trademark and copyright infringement, with harassment. Now that we know there's an expanded workplace, this hostile work environment, the work environment, can be this virtual environment. So how do you have to police harassment in that environment. So how do you do it? Well, you
so
can't.
Anthony, you tell your clients, police, but don't police so hard.
Well,
don't police so much.
I'm chuckling because there's actually quite an interesting case recently from a female employee of IBM who was out on medical and disability leave for an extended period of time. And then as a result of some monitoring, it was observed that she was doing a number of things that were believed to be inconsistent with the disability that she was claiming, including going to the beach and pictures at parties and other things that seemed to be undermining the claim that she was unable to come to work. And as a result, she was terminated and her benefits were stopped. So,
Well,
I mean, there are consequences, and there is a relationship between what you post and what the consequences might be.
Of course, there have to be limits on what the employer counsel asks in a case like this. Now, if Tony sends me a discovery notice and he says, George, I want the password for the Facebook of this person. Now, that is equivalent to me for somebody asking me to give every letter written on every subject to any person for 10 years. So I think that's a bit broad. We can't allow this, and I never allow it, but I don't think Tony would do that. You wouldn't ask for that, Tony, would you?
He's smarter than that.
He wouldn't ask for that type of discovery, the password, I would think.
But I might, if there was a sexual harassment case, for instance, and I'm not making this up.
No, we're going to get to this case. Out of Colorado, right?
Exactly.
Right.
And if it was learned that there were posts by people who were bringing that case on Facebook that related to the case or said statements as why they were bringing the case, then I certainly would make a request
Absolutely.
for that
And
information, and I may be given it by a court.
And this is the original
But it's the same. But if I would have sent you that request, Tony, of your client, and I would say, Tony, I want you to give me every letter your client has written on every topic to any person, you would oppose that. So I think you have to put limits on the kind of, now we've gotten into this other topic now. Now in this, everything you say will be used against you. That's what you said at the beginning.
More or less, yeah.
Which means, what does that really mean? Which means the lawyers are going to get it. And they're going to put it up for the jury to see. The question is, what do they get in discovery? What can they get? How much privacy can they overrule?
See, but I want to come back to sort of a principle and something Michael was beginning to say, which is that I don't think the lines are that clear. We're sort of in an evolutionary stage of both the existence of social media sites and what they mean in society and how the law deals with them. We're not going to talk a lot about the Supreme Court case in Quan versus City of Ontario because that dealt with some other issues, texting and privacy issues.
And ownership of computers.
But in that case, the Supreme Court was asked to establish certain general principles that apply to the rights of privacy on electronic systems, personal systems. And the Supreme Court expressly declined to enter the fray because they said, we don't know yet where social norms are in this area, so how can we as the Supreme Court really create principles? And what we're seeing is that judges are making decisions based upon their own experiences, and they're often conflicting. It's not like you can discern a lot of principles. So you have obligations to monitor, obligations to react, but you have limitations on what you can do and what you can see. You know, every employer now, not every employer, but most employers that are sophisticated are coming out with social media policies and guidelines, and guess what? The National Labor Relations Board, right, which you don't think intuitively of as an agency that has anything to do with general private employment because they deal with issues related to collective bargaining and unionization, have stepped into the fray, and they are saying that these policies are unlawful because they restrain employee speech with respect to wages, terms, and conditions of employment.
Another headache.
The thing that you mentioned at the beginning is, do you need to hire extra people and become full-time in terms of monitoring these sites? And the work I do, as you know, I represent a trade association of employers, the Mid-Atlantic Employers Association, and I tell them, no, don't do that, but rather designate specific people who are highly trained, sometimes on a weekly basis because of the developments from the NLRB that Tony mentioned and other agencies, because you have to be extremely careful about not only what you look at, but what you do with the information that you find. And you would think that you would have an affirmative obligation to monitor very carefully, but there is a downside to the monitoring, and that's what I meant when I said that employers are getting it from both sides right now. Even to the point where, to segue off of what Tony said, I just read a case, I think yesterday, where you would think that in the workplace, perhaps employees should not be allowed to monitor their Facebook pages and spend time on Facebook in the workplace. Maybe they should be doing their work in the workplace. And I think it was a Dish Network decision where the NLRB said that an employer policy that says we're shutting off Facebook in the workplace was unlawful because that might restrain employees from communicating with each other for the purposes of perhaps organizing the workplace or discussing terms and conditions of employment, the kind of thing that the NLRB sanctifies. And so employers, by that decision, I don't know whether it will stand court scrutiny or not, are not even permitted on a blanket basis like so many workplaces do to say, you know what, Facebook doesn't work here. Pay attention to your job as opposed to Facebook. So it is a strange and crazy in addition to being brave.
Well,
in the world.
and let me put up some statistics here. This is from Forbes, and then we've got something here from Technocratic Systems as well. And in Forbes, oddly enough, Mike, the statistics suggest that people don't mess around on social media as much as we may think. As a matter of fact, the bosses, if you will, those in management spend more time on social media at work than do the so-called workers. And then this technocratic information we've got up on the screen right now, suggests that most employees spend time on social media either talking to other co-workers and where they work or customers. So, I understand that, there are probably people getting their hands slapped for screwing off at work and getting on their social media, but apparently not as much, at least according to these statistics, as it might have been suggested.
Well, there's some of the Facebook or social media work that a lot of people do at work is work related. And that's a whole other topic, not somewhat beyond us, in terms of how one can use social media for a bona fide business purpose and the training and the policies that need to be promulgated with respect to that. But it's my position, at least, that if an employer wants to say to its employees, this group of employees, for example, you're not permitted to use Facebook because there's no business purpose for it, for that classification or this work group or whatever it is, an employer should be able to do that. And the NLRB says no, and in addition to a lot of the other monitoring things that you'd think that an employer would want to do. So my only point to this is that the dust is nowhere close to being settled. All the dust that's going to be in the air is not even in the air yet, let alone settled. What George said is absolutely correct. Technology has far outstripped the law. It's also far outstripped any business sensibilities or know-how, and there is an awful lot of changes that are still going to be coming down the pipe.
Let me switch gears here just a little bit and get back to something we were trying to get to just a few moments ago. And it goes to this case out of Colorado, the original honey-baked ham company of Georgia, but it's a Colorado case. A woman apparently was the head of a class, a sexual harassment, employment discrimination case. Sounded like the plaintiff's lawyers. This is your nightmare, George, if you were a plaintiff's lawyer here. Apparently it was a very good case, and she gets on Facebook and she starts talking about how much money she may make from the lawsuit, how she was going through some tough times at the time of this sexual harassment. Her pet died and she was breaking up in a relationship. Now all of a sudden the Colorado judge says, yeah, you can have access to her defendant, you can have access to her cell phone and the password to her Facebook page. Now again, I suspect that's going to be appealed, but that's your worst nightmare.
Well, we're seeing this in almost every case. And the employer very often has these emails. And the employer says, look, the relationship was consensual. Do you see what she said? Or there was no hostile work environment. Did you see that she promised, she said to the guy that's harassing her, I hope you have a wonderful vacation. I can't wait to see you again. These things come up all the time. Oh, that particular case. I'm not that bothered. Now, in that particular case, there was a middle ground. Initially, the court appointed a special master to review in camera the Facebook page and the entries and decide which ones were privileged, which ones were relevant. And then I guess it went to the EOC, a special person appointed by the EOC to do that. I can't say that that's not a fair accommodation. It's not asking for the password. It's not. One of the things that I say is we'll provide you with anything you frame your request in a relevant way, and we'll provide it. Now, what Tony will say is, how do I know that you won't erase some of those emails? How do I know that you'll provide me? But that's not what I say back is, how do I know you're providing me with what I asked for when I ask you for your corporate
documents? And how do you know what
you
the court is going to say, this is relevant and this is irrelevant? I mean, apparently, according to the court, they're saying, give us all the information, we'll tell you what we need.
Well, the initial determination of what is relevant is an appropriate one at this point of the game in discovery disputes. But I think the honey baked ham case is a fair accommodation, I think. I'm not totally bothered by it. But we see these issues every day. That's more of a collective action, 20, 30 people.
It's still a nightmare for you, George.
I think in that case, though, they had specific evidence that something was said, which they got through somebody who was on Facebook, and therefore, they were able to show that there was a direct connection and at least a good argument as to relevance. What I think is a much more problematic area, which is closely related, is not when you're in a court proceeding, but when you're an employer and you're confronted with a problem that you, under your policies, need to investigate, whether it's a complaint that somebody is involved in sexually harassing behavior on a social media site, or whether they're saying racially discriminatory things, or whatever it might be, and now you have to investigate. So how far do you go, and can you ask people in those circumstances to give you access to that site? And you're betwixt and between, because if you look at the Espinoza case that I talked about earlier, it would seem to think you have an obligation to do quite a lot. On the other hand, courts are saying, well, you're pretty limited and you can't go and ask another co-worker who's subordinate to you. There's quite a famous case in New Jersey, Pietrillo, where that's what the employer did, and they got into trouble because the woman said, I didn't feel like it was something about which I had a choice. I felt, I was compelled to do it. I would lose my job if I didn't, so I gave the password, and it was viewed as illegal by a jury. So that's a real dilemma for employers,
and
because
again,
you've got the obligation.
This is a coworker giving a password to
a supervisor,
right? For someone else,
yes.
Obviously.
But if you have an affirmative duty to look into things, because there's this breakdown between the real world and the virtual world, how far can you go? And I know we were discussing before the show, but there's new legislation in certain states. Maryland and Illinois have statutes on the books that say it's illegal to require a candidate for employment or an employee to give you the password or access to a social media site. California is about to pass similar legislation. New Jersey has a bill pending.
This whole notion of privacy at the workplace, when we talk about a right to privacy, let me actually pose this to you, Mike Trachtman. I know you've written about constitutional issues. A lot of people think, hey, it's my First Amendment right to say what I want to at work. This has nothing to do with the First Amendment per se, but it has everything to do with privacy. Help us out here.
Well, the First Amendment protects people against the actions of the government. It's Congress shall make no law which shall abridge.
Not your employer. Your employer is not the government.
Yeah, you're typically an employee at will, and your employer theoretically can do what it wants. But there are many Swiss cheese-like holes in that your employer can do what it once thought. And one of those Swiss cheese holes is that the employer cannot invade your privacy during the course of investigating what you're doing. Employers have a bona fide and have always had a bona fide reason to insist upon loyalty from their employees, and employers sometimes want to know, are my employers backstabbing me? Are my employers doing things that are adverse to my interests? Are they trading with my confidential information, sell it to the competitor? Are they bad-mouthing me? Social media has opened that up on steroids. Now, as I think Tony mentioned, that which was private is now public, and people, somehow there's a psychological block when somebody sends an email. They just sort of think it goes off into the ether and it's private between them and the recipient. And when someone posts something on Facebook, it's just among your circle of friends.
Right.
When it's not, it's off into the universe. Employers get to it, and the question becomes, can employers act on the basis of a breach of loyalty of their employees when they find out about it in those contexts? And the answer is, it depends how they find out about it. And the answer further is, based upon the NLRB issues that Tony mentioned, what exactly did the employee say? Because even if they are being disloyal, the employer still might not be able to do something about it.
Yeah, ask Oliver North and David Petraeus how that worked out for them.
Yeah, well, it's, when you're a public figure, people can say a lot about you, but when you're an employee and you post on the internet that which you used to say to your next door neighbor on a bar stool, and it's the same thing about how your employer is horrible and all the bad things that are happening, that which is said at a bar over a beer as compared to the same thing that's said on a social media site has dramatically different impact to the employer. Sure. And the question is, and the law hasn't really caught up with it, what can the employer do in respect to an employee who has the lack of good sense not to post on a site that's available to other prospective employees, to competitors, what the employee thinks adversely about the employer. What are the employer's rights in that context? And that is a very hot topic that's going to make a lot of lawyers very wealthy.
George.
Well, the case that Tony was talking about, when you asked about privacy, that's a tort. That doesn't have to do with the host of issues involved with public employees and constitutional rights. Mm-hmm. And the issue when you have privacy is, what is the sphere of privacy that you have? What is your expectation? And the courts are starting to carve that out a little bit, just like the NLRB is starting to carve out and saying, look, if you're just talking and ragging on your employer and you're not talking about terms and you're not interacting, we're not going to say that is Section 7 violation.
All right.
Okay, you can do that. And the courts are also starting to talk about what is the sphere of privacy in social media. For example, if it's out there in a website, generally posted, you have no right to privacy. If it's password protected, you do. What if it's a friend's area? Well, then they're carving out this, in some courts at least, this interim area where we're going to look carefully and see, balance the factors of privacy with the need for relevance. That's what we have going on here. We have a middle ground. Like Tony said before, we're developing slowly these areas that are coalescing into perhaps some law we can work with.
Well, employers have dealt with this area to some degree because most employers with good and up-to-date policies are explicitly telling employees that anything that is said on the employer network, on email and a document, is owned by the employer. The employer has the right to review and inspect whatever is written, authored, posted on its network, and therefore there is really no right to privacy.
Right.
The difficulty becomes with social media is that you're really taking one step beyond that. And,
well, you can be writing off your computer at home or typing on your computer at home.
You mentioned David Petraeus. Well, you know, there you had apparently, right, a purely private email site, which happened to be, there were communications from the network, but it was a purely private site. So, you know, the question is, for most employers who do not have the kind of access that the FBI has or the rights the FBI has to do an investigation. And I still wonder what authority they actually looked at those emails under. But nonetheless, employers don't have necessarily the right to go into things that are purely in the private sphere. And I agree with Michael on this. I don't think the lines have yet been drawn, and I think there's going to be a lot of conflict until they are drawn.
And Mike, we're going to give you the last words tonight. What is next in this field? What a brave new world we are stepping into. What is next?
Well, I think the only thing that can possibly start the process of solving some of this is some broad stroke legislation which gives guidance. I think the commentary on the NLRB is extremely important because it has created a supreme disconnect between common sense and business practicality and, in the NLRB's case, law. So too the other conflicts that are faced in terms of privacy versus the obligation to investigate and the rest of it. So if we ever get a Congress that can ever pass legislation, that's where it has to go. In the meantime, it's going to be on a state-by-state basis. The states are taking very divergent paths on this. They really are serving as the laboratory of the democracy, but it can't be left to the government agencies. It can't be left willy-nilly, ad-lib the way it is. The legislative branches, both state and federal, of the government have to step in and start defining this. It's the only answer. It's a jungle right now, and it can't go on that way because we need some predictability, and we do not have it.
Oh, I'm glad I got to 1/8 of my notes and my subject matter tonight. We're going to have to do this again. Anthony Haller hails from Blank Rome. He heads up the Employment Benefits and Labor Practice Group at Blank Rome. Michael Trachtman, General Counsel for MEA, the Mid-Atlantic Employers Association, and George Kounoupis, Plaintiffs' Counsel with the Hallis and Kounoupis, representing the employees. Thanks, guys. So for all of us here at the American Law Journal, until next Monday night, case closed.
Tonight's Law Journal has been made possible in part by Blank Rome, a national multi-practice firm for over 60 years, with more than 400 attorneys in 6 states and the District of Columbia. Blank Rome's highly regarded employment law practice provides representation and strategic advice for critical issues facing employers in today's workplace. Stark & Stark, developing innovative solutions to meet their clients' needs in bankruptcy and creditors' rights, and in over 30 other service areas. And the Legal Intelligencer, the nation's oldest legal newspaper for lawyers.